Hey Facebook friends, sorry for a late start today. We have had a very busy afternoon, and that happens frequently around here, so we had to adjust a little bit. Today we're kind of doing a team thing. Gary's with me today. He doesn't usually sit behind the desk with me, but he is today, just so we can both be here for you. There's a few things we want to talk about today, and the reason that Gary's sitting next to me is because one of the things we want to talk about is how we handle cases as a team. Of course, I do workers' compensation, so does Gary. Gary also does Social Security Disability. Say hi, Gary.
That's right.
When you sign up with us, first of all, you may have seen the Facebook Live from Sean and Norman in the PI department explaining to you that when you come in and see us, you're actually going to meet with the attorney. Your case isn't going to be assessed by a paralegal or a staffer. You're actually going to meet the attorney that's going to handle your case from beginning all the way to the end. You may come in and meet with me, and I can handle your case clear to the end.
That's true.
You may meet with Gary; he'd handle your case clear to the end, or vice versa. If you want to, if you want to meet with Gary and he's not available, and you meet with me, he could still handle your case. That's fine. But the point of having this teamwork that we have is that, for example, I review secondary. I kind of like review Gary's files, and he helps by reviewing my files. And that way, when you've got an attorney assigned, you automatically have a second attorney as a backup assigned in the event that I'm sick or Gary's sick or one of us has to be in court in Western Kansas or in Kansas City. There's always somebody available to assist you with your file, even directly in the courtroom, and it's not going to be the first time they've looked at your file, right?
That's exactly right. And I think one of the biggest benefits that having both of us staffing each file provides to our clients is it really assists with being able to get things done quicker and in a more timely fashion. If you have only one attorney who's available to cover hearings, meet with clients, do doctor's depositions, things can get kind of bogged down, and it's not at all unusual. In fact, I think it's probably the norm that there will be, on any given case, I might be covering a deposition and Todd will cover the hearing next, because that way, if we have to have somebody out in Liberal or in front of Judge Fuller in Garden City, we can do that. We don't have to wait for that one attorney to become free. I mean, we literally go from the far southwest part of the state to southeast corner of the state in Pittsburgh and Independence to the Kansas City area and northwest part of the state as well. And so when you have the flexibility of being able to utilize two different attorneys' calendars and their availability, we feel that it allows us to get things done more quickly, and the quicker that a person can get benefits and can get their day in court and can get the evidence we need from the doctors, the better the result. So we really enjoy kind of working together too, and it seems to work very well for us and our clients, most importantly.
And not to suggest to you that Gary's a lot older than I am, but my first job out of law school, I actually worked with Gary. So we've known each other for a long time, and we work well together. Not only does having two attorneys assigned to every file for you assist with the scheduling part of it, but it also assists in that if you call to the office and you have a question and one of us isn't available and you're not comfortable that it's a question that one of the legal assistants could answer, although I will tell you our legal assistants can answer a great many questions, but sometimes people want to talk to their attorney, and that's perfectly understandable, and we expect you to be able to do that. But if a client calls in and I'm not available, for example, Gary could be available and be able to answer that question. He's looked at your file before, and he certainly has the legal expertise to answer how it would affect you in your particular case, and vice versa. I may end up talking to somebody where Gary's the lead on the file, but I'm answering the question about their file because he's in court in Topeka, for example. So the teamwork that we have here, when we say accident recovery team, we mean it. Every case that you have, you're not flying solo with one attorney and dealing with his schedule and his availability. We are a team, and we back each other up, and that reaps benefits to our clients, and we're proud of that.
Absolutely.
I mentioned you being in Topeka. Of course, we're in court all over the state, but something else that we're involved in, there's always a legislative process going on. Keep in mind that the workers' compensation laws in Kansas are statutorily driven. The benefits available to you are what the law says that are available to you. And so every so often there is a struggle within the Kansas legislature on tweaking those laws. Unfortunately, in 2011, those laws were amended and they weren't favorable for the injured worker. The lobbying groups on behalf of the employer segment of the state were in a position of power, and they made some changes in the statutes that were not helpful to the injured worker. You know, Gary, we talk about this all the time, but a lot of the problem is that the statutes that affect people that are injured, it affects everybody out there if they've never been injured.
Right.
And the problem is they don't know it because it's not affecting them at the moment. And then later on, when they become injured and they learn how the process works, they look at it and say, well, this is hardly fair. But it's hard to pool that public opinion when there's so many people out there that if they understood how it would affect them in the future, they would be up in arms about it. But they're not, because it's not affecting them at the moment.
I think that's right, and that even filters down to the legislators. You mentioned this week, on Tuesday of this week, Sean Brennan, one of our other partners, and I went up to Topeka, and in conjunction with the Kansas Trial Lawyers Association, we went and talked to, 30 or 40 different representatives. A lot of them were very new representatives that have just been elected in this last election cycle to Topeka. And, you know, they're kind of like a lot of the injured people we represent, in the sense that they don't have much familiarity with the process. They don't necessarily understand or haven't had firsthand information about how these rules and these laws and regulations really affect injured workers. And so part of what we were trying to do was to share stories of how these sort of abstract ideas that they're being asked to cast votes on really affect people. And one of the things that's most persuasive to those folks, you know, what really came across to me is they want to know, they want to learn, they want to hear stories about how these rules and these laws affect their constituencies. And so we were sharing that, but you know, they want to hear from injured workers or people that have family members that maybe they've gone through the work comp system. And if there are, part of what we were asking them to do is to revamp and revisit some of these statutes. There are caps that haven't been changed in literally decades. We want to try to make the system more fair, more of a supportive system to help people get back on their feet, get the medical attention they need while they're able to put bread on the table and support their families as they're healing. And so I guess I would kind of say, if you have an opportunity, know who your representatives are, let them know what your thoughts are on the Kansas work comp system, or on the, there's also a bill being proposed that's going to adjust limits on car liability insurance, what type of mandatory minimums are required. And all these things have a hugely important impact on you, your neighbors, your family. And so,
Huge.
Yeah, that's right, as our new commander-in-chief would say. You know, we want to try to be a voice for the people we represent. We would urge you to stand up and be heard in this process as well. I think there's a lot of new blood, so to speak, that's being introduced up to Topeka, and that's a good thing. And maybe we can, you know, roll back perhaps some of the very harsh changes that are made to the worker compensation laws, in particular in 2011 and 2014. So we're trying to do our part to stand up for the folks of Kansas, and we would urge you to do the same.
Because ultimately, the workers' compensation laws are statutory. They're driven by what the statute says. You know, we have people that'll come in and we're helping them in the work comp case, and they're familiar with the term pain and suffering, and they ask about the pain and suffering element. That is not within the statutory structure of a workers' compensation claim. It's a category of damages available in a personal injury claim in different categories, but not within the structure of a work comp case. It's just an example, but we can only seek what the statute will provide, and it's not a great statute. So we're also doing what we can behind the scenes at the legislative level to see if we can't advocate to have some of those laws changed to the benefit of not just our clients, but our future clients and the people of Kansas. So I did also want to talk about, you know, when we have a work comp case, sometimes it's not in a vacuum. It's not just a work comp case. We will have a case. We have been on Facebook Live, and we've been on the radio, and we've We've posted some videos on our website addressing frequently asked questions about work comp cases. And when we answer those kind of questions, we're typically talking about just a straightforward work comp case. One of the things we hadn't really talked about was when you have a more complicated animal where a work comp case is overlapping with some other area of law. And we can have that in a couple of situations. One of them kind of happens at maybe the beginning of a case and the other at the end, and I think Gary's more qualified than I to talk about some of that. But the part that can happen as a case is born from an accident is, if you have an accident that occurs at work, the work comp statute would be implicated. But if you have an accident that happened at work but is also due to the negligence of a third party being not you, the injured worker, and not your employer, but somebody else, then you can also fall into the general tort of personal injury, where you may have a claim against the tortfeasor, the person that was negligent and caused the damage to begin with. The overlap there is a little bit complicated in the sense that the first party responsible would be the work comp carrier for the employer to step in and start providing the benefits. That would be, like we've talked about before, treatment, off-work benefits, ultimately some compensation for the injury or the effects of the injury, such as wage loss or task loss, and even into the category of future benefits, future medical treatment, future compensation that we could address post-settlement or post-award in a work comp case. But if there's also that lingering case out there against the person that caused the injury, our office would be pursuing that claim as well. That insurance company then would have a claim called a subrogation, meaning that to the extent that our client is going to collect money both from a work comp carrier and let's say it's a car accident, the insurance company for the automobile, that second carrier is going to want, when they pay, the work comp carrier is going to want credit or some of the money back out of that second claim. It's called a subrogation. Just as an illustration, if you collect $50,000 in a workers' compensation claim, and this would be in all categories, medical benefits, off-work pay, or compensation in the way of an indemnity paid to you. But then you also turn around and then the separate claim, you were to collect $100,000 from the party that caused the accident to begin with. As you're waiting eagerly for your new check for $100,000 to come in on that claim, the workers' compensation insurance carrier is going to be standing there with their hand out saying, we get paid back first. They had to pay you because of the statutory requirement for them to pay you. They weren't the one at fault. So they're going to want their $50,000 back. In that overlap, what we try to do is negotiate as best as we can a reduction of that lien so that our client can maximize the benefits available under both cases. Now, there's a lot more to it than that, but that's the broad stroke. And when you have a law office like ours that handles both personal injury and workers' compensation, quite frequently our office is handling both ends of that process, and that helps us in terms of being able to communicate and in terms of us being able to negotiate the best result combining those two cases.
No, that's absolutely right. I mean, some examples that we commonly see that implicate both a worker compensation and a personal injury claim would be if a person does sales or their job requires them to travel, and in the course of traveling for work, somebody runs a stop sign and runs into them. They originally get their benefits, whether it's medical treatment or off-work benefits through work comp, but then there's also a claim that can be made against the person who actually caused the harm, the negligent driver. And if you have one attorney handling both claims, you don't have to, but there's some real benefits, some real efficiencies in how you have a unified approach to trying to get the most benefits you can from both sources, the work comp carrier and the personal injury carrier. You save on expenses, which relates to a dollar-for-dollar savings for you. If our goal is to put the most money we can in our client's pocket and to get them the benefits as quickly as possible, and the way you do that,
and we get paid too, Gary.
Well, and that too. That's absolutely right.
Everybody wins.
but the thing is, the way we can get the most for our clients as a benefit is to get the most we can from the other parties, but also to keep expenses down and to do it in a timely fashion. So if you have one attorney handling both cases, you don't have double the expenses for getting the medical records. You have a lot of efficiencies that really relate to savings for you. But we've had situations where that arose, where a person doing construction is injured by a faulty machine that's manufactured by a third party. There's both a products liability case and a work comp case. We have situations where two different subcontracting groups are working on a roof and one fellow is hurt by another party, a third party's negligence. So again, I mean, there's all sorts of situations where those things happen. I think probably the key is if you've been injured, if you have a situation like this, these things can be a little bit more complicated than they might appear at first glance. The thing to do is take the time to go in and talk to us at Accident Recovery Team. You can contact us at 267-TEAM, T-E-A-M. Our consultations are free, they're confidential, and you have the opportunity to kind of have this looked at by somebody who's familiar with these issues. And honestly, the greatest recovery comes not just necessarily from one action here or one action there, but from doing both actions and trying to do it in a way that's going to maximize your recovery and get you back on your feet as quickly as possible. And the other part that sometimes where there's this nice synergy between accident work like we do, helping injured workers or people that have been in car accidents, is another resource that sometimes comes into play is Social Security disability.
And that comes up in two categories. There's let's say we have the work comp case and we've worked out a settlement or an award, and there's a compensation that's being paid. Within the work comp system, there is a presumption that payment of benefits to you covers a particular period of time. And then there's the issue of, well, that same settlement can also result in you being granted future medical rights. Well, both the compensation side of it and the future medical side of it creates an issue once we start looking at Social Security disability and Medicare, because if you apply and qualify, now Social Security is looking at paying you a disability, and they're looking at putting you on Medicare, which addresses future medical rights. And so now we have potentially a conflict, or at least we have Medicare's interest is now out there, and you've got the work comp carrier versus Medicare, and you might be stuck in the middle trying to figure out, well, who's paying me what and who's responsible for what. And so how do we address those two categories, Gary?
Well, in the context of the work comp case, there's language, there's stuff we can put into the settlement that tries to preserve and protect the recovery you get through work comp to keep it from being offset by Social Security benefits. We also try to negotiate with the different lien holders, subrogation holders that might have an interest and have their hand out trying to get some of the compensation that you've worked to achieve, and try to minimize that. So, I mean, you want to kind of have a holistic approach to this. You want somebody who's going to be aware of all the different issues involved in all different aspects of the case and can address that for you. And I think, frankly, here between you and Sean and Norman and I, we've had lots of experience in handling those things, and we have the background to get the very best result we can for our clients.
That's right. Social Security has their own interest at stake. If they're going to look at paying disability benefit to somebody, they are entitled to and will aggressively pursue any type of set-off that they can claim under the theory that, well, you're already getting the equivalent of a disability benefit from another source. Therefore, they would want to take a credit or reduce what they would otherwise pay out to you. And they would look at the money you received in a work comp case as being duplicative, or something that they could take a partial credit against off of what they would otherwise pay you. And they look at it, they know the law, they know how the structure of the statute would say that these benefits would be paid out over such a period of time, and they would want that credit for any period of time that they would overlap with that. And the difficulty here is this may be a situation where you've already received the award, you already have that money, and now here they are trying to take a credit. This is something that we have to plan ahead. If you have somebody handle your work comp case and you think it's over and it's done, and then as an afterthought you go pursue a Social Security disability claim, that attorney and the original attorney on the work comp case obviously did not work together to maximize how those two things would work together. The way we do that is we know that in the work comp case there is the possibility of Social Security, and we want to plan ahead as to looking at how is that credit going to come into play and what can we do for our client to maximize their benefit, but still, as legally required, protect Social Security's interest. And there's language that addresses how an award or a settlement is paid out that then helps Social Security understand the amount of credit that they're going to be entitled to over what period of time. But having an attorney or two attorneys within one office that can work together on that concept, one that's handling the Social Security disability and the one with the work comp, that are communicating and working together, it's much better benefit than handling those two cases separately or outside of two different law offices at two different periods of time, two different attorneys. When it comes to the Medicare issue, if workers' compensation is wanting to close out the medical with you, first of all, you don't have to. It's something that's negotiable. You can either retain the right to future medical in some instances, or you can negotiate a closure of that with additional compensation. The difficulty is, if you're going to pocket money in exchange for the future medical, and then turn around and say, well, now I want Medicare to address this for me. In simple language, Medicare gets pissed. They don't like that idea. And so Medicare has statutes in place that would prevent that. They won't cover it. And we don't ever want a client to be in a situation where they were anticipating there would be coverage and there isn't. So again, it's a situation where there are ways for a work comp attorney to work out a settlement regarding the future medical to maximize compensation to our client, but still be in compliance with those laws that pertain to Medicare and protecting Medicare's interest as well. It's a concept called a Medicare set-aside trust, and while complicated, we have done them many, many times for our clients, and it's turned out to be, if you do it right, it's turned out to be a wonderful method of bridging that gap. About right?
I think that's very well put. I wasn't sure you could say pissed on Facebook Live.
I don't know if you can either. If I'm not supposed to say that, I apologize. I've said worse off the air, right?
I'll take the fifth.
If you want to complain about what I said on the air, you can put it in the comment section below. Or if you have any other questions for us at the Accident Recovery Team, you can put those in the comments below. We're also going to be posting some things on Facebook, or excuse me, on our website about the legislative activities that are going on in Topeka. So if you want some insight into that, you can check us out on the website. 267-TEAM or 267team.com on the website, Facebook, or by phone. Consultations are free. Anything else, Gary?
Don't settle for less would be the only thing I'd add.
Talk to you next time.
Bye.